Anyway, guys, just bear with me a sec whilst I do the usual stuff here. As always, this ain't legal advice. We're going to do our best here to be helpful as we can be, but we're not going to have enough information to even come close to giving a full answer to everything. What is the other thing I've got to do here? Hold on. That's not doing it. Hold on. That's better. Cool. Yeah, so yeah, not legal advice. And please, please, please do not share questions in the first person. I will delete questions that come in the live stream that are not anonymized. So ask the question as a what if question. What if someone had been told to wait until the bailiff comes, blah, 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 blah. That's the way you ask the question, not I have been told to wait until the bailiff. You'll get the same answer and you don't have to put all your personal data everywhere on the internet, which is awesome. We've had loads, we've had a lot of questions coming through the week and some of them are meaty. So we're going to get going with them pretty soon. I'm not even quite sure if we're going to have time to actually get to the live stream. We'll have to find out basically, but there might be quite an early sort of limit on when we stop questions. So just another kind of point to make that if you want your question definitely answered in the live stream, then the best way to do it is to put it in advance on any video on the channel. Just find a video on the channel, ask your question. I'll get a notification. It also means I can keep things organized as well then. So let's start going. Any gossip for anyone before I start actually? Any useful, I don't know, information come out at all about homelessness? No? Cool. Will was just saying that the legal aid system's gone down, which I can't imagine is going to help solicitors out. Right. So let's get on to question one, which is, let's zoom in as well. So what if the court, so this is on the back of a couple of videos I've done this week about the bailiff. What if the court has given you until 22nd of May to vacate the property and the council does not change priorities? What if you need help claiming compensation but cannot find a solicitor who can help? Who can you go to before the bailiff arrives? So in the video I did about compensation for being advised or being told to wait until the bailiff comes, I made the point that you can complain about it and it's a pretty straightforward complaint to make, but it doesn't give you a quick answer to it. It's going to take months probably to actually resolve anything. Now, you could involve councillors. You could make a big fat complaint, front load it, send it to the chief exec and so on, copying all the relevant politicians. And that is reasonably effective at getting councils to actually operate properly, but it's not guaranteed. So what I said in the video was if you're being advised and you need an outcome right now, is you need to find a solicitor who can take it on. So you don't need a solicitor to actually claim compensation. That can happen anyway. But in terms of getting the council to budge, unless you can do it through the complaints policy, the likelihood is you'll have to wait until the last minute. Council then steps in, and you then claim compensation later on. So there was another case today, actually, I think involving Hillingdon, that was in the LGSCO notification weekly update. I think the guy got £800 or something. So that's again fairly typical sort of amount. Don't know how long it took him to get there. Are you right, back? So yeah, that's I think my answer to the question. I'm going to keep it fairly short and sweet. So guys, if you've got anything to add in, just interrupt me or whatever. So I don't know if there's anything else to say about this one. I don't know if you see this, Will and Caris at solicitors, whether this is something which you actually deal with when someone has been told to wait until the bailiff comes in real time, or does it ever come your way, really? Got a little nod from Caris there, so I guess it happens, yeah. Yeah, okay, so Will's nodding as well. So yeah, if you can find a solicitor, by the sound of it, Will and Caris are up to their eyeballs right now, so I'm not sure if they have capacity right now. But there are, if you go on Will's website, I'll put a link into the chat at some point, but Will's got a list of legal aid funded solicitors that you can get around housing stuff. So yeah, check it out basically. That's question one. Question two is a long one, but it's not kind of unnecessarily long. It's just quite kind of a complex situation. So so long it won't actually fit on the page. Hold on. Where's the layout gone? There it is. Just make that narrow for a minute, see if that's any better. It's vaguely better. So hold on. Yeah, there we go. Okay, that'll do. So what if an individual fled domestic abuse but owned her own home with a mortgage on it together with the abuser? She fled with her 3 kids and was told she needed to pay for a temporary accommodation, which was around £500 a week. They since sold the house, but she didn't get much cash out of it. Luckily, she was able to move in with her mum and sister who live in a 2-bed flat. So it's 6 people living in a 2-bed flat. The sleeping arrangement's really bad. They're living there after 4 years and she feels trapped because she can't afford the rent despite working full time. She would need a universal credit top up, but she also wants to save to buy a place. And the problem with you about universal credit is that when you get to 12K, you're no longer eligible for it. So then you end up spending your savings on rent and start all over again. You see in round and never getting out of renting. Social housing would be a much better option where she could afford to pay rent with no UC top-ups and then eventually get back onto the property ladder and hand over the social housing to the next person who needs it. She made a Part 6 application 2 days ago. So I went back to her basically and said, has this person made a homeless application yet? And they said, well, they made a housing register application 2 days ago. She was wondering whether she should make a homeless application or not. She fears she'll have to move into temporary accommodation, but she feels more secure at her mum's, even with the messy sleeping situation and overcrowding. She doesn't want to disrupt the kids' lives and has to move from place to place. They've been through a lot in their young lives. She doesn't want to destabilize kids' mental well-being in any way. She just doesn't know if making homeless application refuses temporary accommodation, if that will impact the chances for getting a council house. Can you help with this question? So, a lot of stuff to unpack here. The first thing I'd actually say is going back to the advice this person got from the council that she had have to pay the £500 a week. That would only be if that was affordable. So although temporary accommodation does cost money, in a situation like this, and it's not actually that unusual, where you can't claim housing benefit because of your assets, which are tied up in the house, which you can't access straight away, the council has a duty to provide suitable accommodation, which means it must be affordable. And they would need to actually sit down and assess whether the income you're currently getting would allow you to afford, all the essentials of life and that amount of money. So there would potentially be a complaint. Now, I know it's well out of time in theory because it sounds like it's happened over 4 years ago, but the LGSCO will investigate complaints where someone's only just become aware of the issue. So, that's a possibility, as what I say. So as I say, that was my first thought. Then we get back to this idea of someone who is legally homeless, which this person is, this family are, but would making a homeless application basically mess things up for them. And I could completely understand why someone would rather stay overcrowded accommodation with family where they know where they're going to be, kids presumably at school and so on, rather than go into unknown temporary accommodation, which could be basically anywhere. So that makes sense. In theory, if you make a Part 6 housing register application and in a situation like this where you are clearly legally homeless, they should deal with it as a homeless application anyway. And you can explain to the council your situation and say, look, I want to make a homeless application, but I don't want to move into temporary accommodation. They should be like, yeah, great, no problem. We'll kind of keep it open for you. There's a case called, it's one of the Birmingham ones, I've forgotten off the top of my head, but they made this point to say that the council don't have to provide interim accommodation, but should the circumstances change like a few months down the line, then the family would be able to go back to the council and the interim accommodation or the temporary accommodation would kick back in again. So that is a possibility worth discussing with a decent, competent housing officer. That might be one of the ways to approach it. Now, as it happens, I recorded a video today, which I haven't put out yet, which was specifically looking at the pros and cons of making a homeless application versus making a housing register application, which this kind of situation would be very relevant for. So I'm not going to say anything more than just to say wait until tomorrow when I post the video. I might even do it tonight, actually, just because that will kind of give you a bit more of an understanding of what the difference is between staying under Part 6, which is probably what they're at the moment, or making a homeless application or getting the council to accept it as a homeless application. So yeah, that's my answer to this. But guys, have you got anything to add to that or take away from? If not, we'll go to the next. Go on, Will.
No, I was just going to say, no, I don't really. I mean, other than just to sort of wring my hands about the non-available, the shortage of social housing. So the problem is making, I mean, I don't want to speak out of turn until I've seen your video, but the worry for me is always if you say to people, well, make a housing register application, but you just don't know how long you're going to be waiting.
Yep. So
So
yeah,
that's it.
what I can say or what I can confidently speculate is that it varies massively around the country. So I did that video back at the beginning of the year about the average waiting time for people owed the main housing duty, which this family ultimately would be given a few months. There was a similar stat put out there a couple of months ago, which was the amount of time it would take councils to clear their housing register of 3-bed and larger properties. And the headlines is that places like Greenwich and Enfield were like over 100 years, but that's not the same thing as an average waiting time. But I think I take Will's point. If it's in a London council, the Part 6 process will likely take decades, certainly years, which won't be much help. So I would say that making a homes application would be better potentially, and that you don't have to accept the interim and temporary accommodation. You can say to them, I'm okay with the family for the time being, but should the circumstances change, we might come back to you and be in need of it. And at that point, the council would have a duty to provide it. It's not the same thing as refusing temporary accommodation or kind of abandoning temporary accommodation. It's not the same idea. You're basically having the agreement with the council as you're doing it. I'm literally trying to remember. Is that Edwards v Birmingham? That's it. Edwards v Birmingham. They make this point explicitly in the actual transcript. So yeah, I think again that's a coherent answer. But there may well be some more information that this person or this family can look at the video I publish later. So that's that question. Next question, this one here, which came in from not on the YouTube channel, came in a different way. So frail lady in her 80 years old. She cannot read or write. She has memory issues. She recently had a fall, has heart problems, diabetes, and is currently being assessed for possible dementia and Alzheimer's. After a lot of pressure, the council had placed her in a HMO, completely unsuitable. And we've just discovered they've closed the adult social care assessment that we also fought for with a note. Client declined it. The client has problems understanding things on the phone and would not have knowingly done this. Any suggestions, please, for getting the council to take appropriate responsibility for this client? So it's a London council. You probably won't be surprised to guess. Okay. There's obviously at least two issues here. One is the unsuitability of the HMO accommodation. And I guess we're talking unsuitability. Well, we've got someone who probably has pretty significant care and support needs anyway, and is very vulnerable to exploitation, you'd imagine. So there are two reasons why the HMO might be unsuitable, or why you could argue it's unsuitable. But I think my first response to this would be to go back to adult social care and say, you idiots, what are you doing closing this case down? Clearly, we've got someone who's got questionable mental capacity. You don't close the case down just after one phone call out of the blue with them. So I'll actually go back to adult social care first, because that may actually be a quicker route to getting suitable housing. It may well be this person either needs sheltered accommodation or something else, something more than a HMO, basically. So I'd get the social care assessment done properly first, work out what support would be available to her, and then work out what you're going to do about housing, because it may well be in the course of that assessment that social services are going to say something like, this HMO is not suitable for this person, which it may well be that social services end up housing her anyway in kind of respite or a care home or something, a setting like that. But that would be my answer to this, or my way of approaching it. Again, guys, any alterations or additions to that at all?
Just additions, really. It's depending on who's written this and the capacity they're writing it in. But if they're not a professional, I'd really recommend getting a professional involved that's outside of social care and housing, and more in sort of advocacy and the medical side of things. There are a lot of Alzheimer's and dementia groups and sort of medical groups that can provide sort of professional advocates and chaperones even, just to make sure that nothing sort of like we've had here, she's not accidentally declining anything, or just as a fail safe. So I'd really recommend that. And I think if it is a family member that's written this question, don't feel guilty about sort of passing it off to a professional, because this is all legal stuff. This is hard. Caring is hard. So to add this into potential caring responsibilities already, yeah, that's what I was going to add into that.
Yeah, that's cool. It's really helpful. Yeah, I mean, Age UK would be an example of the type of organisation Shannon's talking about there, but there's plenty of other ones around, particularly one specialist around dementia and stuff. So yeah, yeah, cool. Okay, well, I'd say, and I would also at some point complain about this, because this isn't defensible really. They should, yeah, that just sounds like a very poor social work practice, and also, yeah, unsuitable housing in the first place. So yeah, hopefully, but as I say, I think that kind of route is going to probably lead to more options than just trying to fight the housing on unsuitability in the first place. And obviously, potentially if the assessment's ongoing for dementia, then that may well also throw up new information, which is going to be relevant as well. So question 4, bear with me a sec. Okay, so I think, again, this is written by a friend or family member or something. So what if someone is currently in band 1 and on auto bid? However, there are some areas I'm very worried about them winning a property in, as they have previously been attacked in those areas, which resulted in them getting a brain injury. I have 2 questions. Is there anything in the housing law about not being placed in an area where they're a bit risk in? Also, is there anything in the law I could use around being placed on the other side of the city due to the neurological condition and mental health challenges? They rely heavily on my support network, which are on this side of the city. If they were placed in the property on the other side of the city, it'd be very difficult for them to visit and kind of get daily help and stuff as they do. I'm currently writing a letter to the housing officer to explain this. Just want to know if there's an actual law I could use to ensure this isn't dismissed. So it's a very good kind of point to be arguing about. The first part of the question is, I'm guessing here, if someone's been attacked so badly they've got a brain injury, there may well be police investigation or some kind of safeguarding work that was done at the time. That will be helpful. Now, again, we always kind of come back to this, yes, arguably you don't need evidence of abuse all the time, but it's very helpful pragmatically to actually have it. So if there is evidence of a particular risk or a particular issue in a particular area, and it won't just be the actual ongoing risk from the perpetrator, it might be just the PTSD that may well have resulted from it. And so, kind of being in a particular part of town might kind of, raise anxiety and kind of and cause further issues. So in terms of, is there anything in law? I'm trying to think of anything you can kind of quote. So I know it's not domestic abuse, or it doesn't sound like domestic abuse we're talking about here, but you could probably use some of the principles of the domestic abuse chapter in the Code of Guidance to shore up your argument. I'm not sure if there's anything in Chapter 17 of the Homelessness Code of Guidance as well. That's all about suitability of accommodation. These are, as I say, this is a very good kind of argument to make. I'm just trying to work out what things you could, kind of what kind of self-contained sources you could quote to bolster your case. So I don't know if the others here have got any ideas on that. That'd be helpful, because I'm drawing a blank. But yeah, I think that's a very sensible argument to make. And then in terms of the care and support, again, one of the things councils keep getting in trouble for around suitability of accommodation is that they never actually properly assess the information in the first place. So there was an LGO case I did a little video about, I've not published it yet, last week, which included that problem. And it's just a common theme when the LGO SEO start investigating, there is no evidence whatsoever that the council actually ever considered the support issues or these relevant issues at all. And for that reason, they would then basically lose the argument and would certainly have to pay compensation for the distress and the nonsense they've caused. So that's kind of the principle, is that the council would have to provide a coherent rationale for why they have, even despite the brain injury, despite the attack, despite the fact that the support network is not going to work out in this situation, why they still think an offer on the other side of town would be appropriate. So I think that would be my answer to this, but it may well, and if I think of anything else, I'll come back to the person. This person came through on YouTube, so I can go back to the actual original comment. If there's kind of that sort of self-contained stuff that would be good to quote, or kind of examples of case law or LGSEO decisions that would be useful to quote. But I don't know if, Shannon, have you got anything on this one?
Maybe I'm trying to find like actual useful bits, but basically you've got NICE's guidance, homelessness and integrated social health care guidance. And in there, I remember there being certain things around suitability of like support networks and stuff. So it's probably worth checking out that guidance and having a bit of a search through. And there are also, and I haven't read this guidance, so I don't know how good it is, but Homeless Link is specific guidance on brain injuries and homelessness. So again, I think there might be some, even if that guidance isn't useful, often these guidances will reference other bits of law and other guidances that are useful to sort of bring into the conversation. I'm just trying to find like actual useful snippets in it, but it'll take me a while. But yeah, those are like starting points. And I think there's also like the Brain Trust have got some it's essentially quite common to have like people with brain injuries and homelessness. So it's definitely worth looking out for like resources and bits of guidance. And even if it's not uh legal or statutory, it's still useful to sort of help build the case and to say like the research says this, this massive organization essentially that has funded this bit of work has said X, Y, and Z, just to sort of throw into there.
Yeah.
Yeah.
Yeah, no, nice. I mean, I know what you're saying. It's not law as such, but it's weighty stuff. I've certainly used it before. I think the other thing I probably, yeah, just kind of thinking on the hoof here is that as an adult social care assessment for this person as well is going to be really informative, because again, these are things which the social worker, provided they don't try and ditch the client by ringing them up in Tesco or something and saying, "Oh yeah, do you want the service?" But I think if they actually did a proper job here, they would be assessing all of this stuff. So assessing the brain injury, the support they're getting from the carers, and the importance of it. And if it's a unitary authority, unitary council, then that puts a direct motivation for the housing team to work in tandem with the social work team. Because if the housing team were to go ahead and house someone, 5, 10 miles away on the other side of the city, and then social services have to pick up the slack in terms of the care package, then there's an argument they could be having between themselves in terms of actually making that making sense and doing something reasonable there. So yeah, make the argument. Say if we come up with anything in terms of directly quotable, Shannon just mentioned a couple of resources. Shannon, do you just want to write in the nice guideline title into the live chat at least, so people can go away, Google it, and then yeah, adult social care assessment as well would be awesome, I think. So next question from that came through the week. Don't know the answer to this, but I'm sure one of us does. So if the person acquired a CCJ and a low credit score due to her health, but prior to that paid all the bills on time, and it seems unfair that this isn't taken into consideration when applying for a property through an agency, that the person is now stuck in a HMO with medical evidence of PTSD, but nothing can be done. So I think the problem you got here is that in terms of like private rental agencies, they don't really care about anything other than making money. I'm sure that's not entirely fair. But certainly some agencies, they just care about making money. So if someone has got a CCJ on their record or whatever, on their file, then the agent will simply go to the next potential tenant, because they've got a never-ending supply of tenants basically, and they'll just find a tenant who doesn't have a CCJ. So although the council, if it got to as far as kind of going to a council, the council would be able to take that kind of thing into account when it's kind of like, when they're looking at types of properties and so on. I think a private rented agency is not in any way bound to do the right thing. They're just going to generally just kind of take the hot, cold, kind of cold, calculated approach to it and just say this person is a risk on paper, so we're not going to put them forward for a property. So yeah, I don't know if anyone's got anything to add to that in terms of, or any advice around what you can do about a CCJ, or how long it lasts, or what's possible with it.
I did Google this earlier on, and it's not that much comfort, but the county court judgment remains on the register of judgments for 6 years from the date of the judgment, unless the full amount is paid within 1 month of the judgment date. And if you pay it within that month, the entry can be removed, but otherwise it remains for 6 years, which is a long time. But if it's more than 6 years old, you should check it's been removed. But the other problem is a lot of agencies have sort of private credits reference places. I don't know if you've ever tried that. You apply for credit and you find that you got a negative status because you shared a house once with somebody who had a county court judgment, and they can literally do a search on that and then say, well, sorry, but it seems like you hang out with the wrong sort of people, so we're not. And there's very little you can do about it, I think.
Okay, yeah. Yeah, I can't see an obvious answer with housing law or homeless law here that would actually make a difference, I don't think. I mean, again, you potentially make the argument you would need very, very strong and clear medical evidence about the impact of the property on PTSD. But as we kind of said before, that's a very high hurdle to cross. So it's technically possible, but it's probably unlikely without a very, as I say, very clear psychiatrist letter or something just evidencing that. So question 6. Oh, it's a big one. But again, it wasn't overly long. It was kind of, it covers its Yeah, kind of goes into a bit of detail, but we need to. So, right, applicant is single male prison leaver with underlying physical mental health issues, one of which means he's automatically considered disabled under the Equality Act. Homes application made and interim accommodation is provided in a HMO in borough, and client is essentially forgotten about for 3 months. No contact from the local authority at all. Just before Christmas, housing officer cut off emails off the cuff telling the applicant that she intended to find a non-priority to vulnerability, but would refer him for supported housing via the council's vulnerable adults pathway. No PHP produced, no relief duty notification or other paperwork, no section 184, no section 193, nothing. Initiated complaint under the council's process and stated how the process had been unlawful, advocating on behalf of the client and got the assessment redone and PHP issued. Client complaint continued and was a couple of months late to begin with, did not find fault with the council actions when it finally arrived, asked for stage 2 review as the council still hadn't produced an acceptable section 184 decision but fell on deaf ears, followed up again and said would refer to the LGSCO directly unless they responded in line with the policy, and didn't wait until the remedial action had been taken in order to not uphold the complaint. Officer finally produces their attempt at a section 184 notification decision, and with it a notice that the relief duty has been brought to an end and the section 188 accommodation had been cancelled with a 2-week notice period. Requested section 202 for both the section 184 non-priority grounds and the decision to bring relief duty to an end, as they actually hadn't done anything to satisfy it. Received acknowledgement that both reviews were accepted, but council asked for 12-week extension due to staff sickness. Nothing to lose, so agreed. Fast forward 3 months and the council decides that it did fulfil the relief duty, so issues a section 203 decision in council's favour. Same day, council temporary accommodation department cancels client's TA 2 weeks notice given again. Challenged them and argued that the TA was confirmed as being provided for both section 202 reviews. So the ending of one didn't impact the power to accommodate being exercised on the other. Council then responded asking for the client to sign consent form for the council's independent reviews company to conduct inquiries for the non-priority section 202, as it had already been provided 3 months ago in time for both requests. Does this mean that the council is only just beginning the review of the priority need decision, and therefore does the additional time requested, still an additional 12 weeks on top of the statutory due to ongoing staff sickness apparently, start from now or when the complaint review requested was submitted previously, i.e. when can pressure start being applied for a decision on the vulnerability to move things forward? So I know that's a bit of a mouthful, but first of all, fair play to this person for basically digging in and doing this. I think they've got a good chance of success. I would guess, unfortunately, that the independent reviews company may well be Housing Reviews Limited. So in my experience, you can probably expect some absolute nonsense. But that's just the game, I guess. I actually don't know the answer to this, but my guess is that the review period started the moment you put the review in, and so there's not 2 consecutive reviews going on here. The reviews were put in simultaneously, and so in terms of I guess I don't know what the next step would be in terms of going down the court process, but yeah, that's my guess. But given that Carris and Will are solicitors, I'll leave it to them to confirm. Will, what's your thoughts?
I agree with you that the review period would start when the reviews, or for both of them, maybe you've got 2 review periods here, but if they are both, it looks like they were both asked for at the same time, so it would run from then. So they've got 8 weeks to complete the review, but they can extend that. So if that initial request for 12 weeks was agreed, yeah, it was agreed, it would continue then, but it's basically measured from the date when the review was requested. But what I don't done, can I just say, sorry if I'm sort of going astray, but I can't understand. There's something wrong at the heart of this, because when the housing officer says, I'm not going to find you in priority need, but I'm going to refer you to the vulnerable adults channel, that's a sort of contradiction in terms. I mean, if either if you're considered to be a vulnerable adult, I'd have thought you'd be vulnerable and therefore in priority need. Although it could be that vulnerable in terms of that particular meaning of the word isn't vulnerable for the purposes of accepting a duty. But I would have thought the best, and what I don't, is there anything in there about what happened after they cancelled the temporary? I mean, did they
So I think
that or extend it?
I think it sounds like they reinstated it whilst the first half of the review was done, But then they say, well, yeah, we still need to actually look at the non-priority decision. And it sounds as though they have refused to accommodate pending the outcome of the second half of the review. I know it's weird to kind of talk about those terms because it should have been done all in one go, but I think that's what's happened. So I think what's basically happening now is they've ended the temporary accommodation duty, but the review, the outstanding review is still going to be potentially 12 weeks until they actually get an outcome, during which time this person is going to be homeless. So
that would mean you'd have to request accommodation pending the outcome of the second review, and
yeah.
then judicially review them if they refuse to provide that.
So I think I think this person knows what they're doing. I think they have had the argument with the council to say that they still have a power to accommodate whilst this
Yeah.
second the review goes on. I mean, I guess this seems like a good case for a solicitor. But as I say, I know you're up to your eyeballs, Will. I don't know if Karis has got capacity right now, or is it over?
There's been about 3 or 4 so far. The 2 that had adult social services involved were good cases for solicitors, or cases where a solicitor is necessary, really, because sometimes it just takes the threat of legal action or legal action itself to just get the wheels to start turning correctly. Because this council here seems to have got into a right mess. I just don't know why they don't just say, okay, you're in priority need, and we'll refer you to the supported accommodation and discharge of the Section 193 duty.
I mean,
But
so you mentioned it, Will, but certainly when a council has a vulnerable adults pathway, it's not exactly the same legal meaning, but it's clearly an indicator that this person is vulnerable. Because I mean, I've had that argument before with Bedford, actually, when someone was under the rough sleeper multi-agency panel, which was meant to be for people who are vulnerable, and yet they were trying to say someone wasn't. So I kind of used that as kind of
so
part
it's
of the
sort
argument.
of vulnerable with a capital V or vulnerable with a
Yeah,
small v,
yeah.
or but it'll turn on. I mean, I guess it'll turn on the medical evidence, won't it, or whatever the other arguments for saying priority need are there.
I mean, if it
So
is a ridiculous independent review company that's doing it, then you can guarantee that review is going to come back and say non-priority, and then the council's probably going to accept that and say, yeah, non-priority. So this seems to me to be a case which is likely to go. It's going to probably need a Section 204 appeal. That would be my
yeah.
guess or my fear. So getting a solicitor involved at this point would be a good reason, yeah, good thing to do anyway, I'd say. Karis, you got anything on this one?
No, I was going to say, when they just the last bit when they said, when can you start pressure being applied for the decision, they would still, I would mark the end and say you'll start chasing near the end of that 12 weeks. But they still might not give you a decision and still turn around and say, oh, we'll extend it a bit more and extend it a bit more.
But so how many? But if the essentially what's happened is that the review should have all been done in one go. It seems to me they had the 8 weeks. They already asked for an additional 4 weeks. Now they're asking for an additional 12 weeks. At what point do you say we're going to court?
Stop agreeing.
Like, yeah, we've had enough.
Well, yeah, when you feel like it, basically, because it's supposed to be 8 weeks. So if you've given them an extra, or if you agreed 12 weeks to start with, then you're perfectly entitled to say, when they ask for another extension, sorry, I'm not agreeing this. I'm going to court now. Or you could say, I won't give you 12 weeks. I'll give you 1 week, because you've had a load more than you should have done already, and then just go to an appeal.
But
Yep.
extending the decision would give you more time to get a solicitor, wouldn't it? To get that, because once
Sure,
the
yeah. I mean,
decision,
I'm saying that as a solicitor.
yeah,
Yeah. But
I would say extend it as much as you
Sorry.
can while use that time to get a solicitor
but
to
it
do
seems to
the
me.
Section 204 appeal.
So I think if so councils. So again, I don't know if I assume we're in this 2 week notice period for the temporary accommodation ending. So there is some serious urgency in terms of this person being street homeless or whatever, and clearly this is someone who's at risk of probably quite a few harms. Shannon.
Well, I'm not a lawyer, which is probably quite obvious from how I answer these questions. But this person's got multiple sort of disabilities at the top, it said, didn't it?
Mm-hmm.
And I can't imagine that this situation has made any of them better. And I would imagine that it's probably had a detrimental effect on some of them. As a non-solicitor, and just because this feels so messy. I mean, the person, by the way, is doing a blinding job. Like, fair play to whoever this worker is, because this is not easy stuff. In my head, a fresh application based on the fact that, you know, one of their health conditions, I'm going to assume, has gotten worse, even if it's depression and anxiety, with all of this going on and the risk of imminent like rough sleeping. I would potentially be looking at making a fresh application, because again, you're triggering that temporary accommodation duty early. It gives you that extra time to find a solicitor, because it feels like the council has, and maybe I'm just being paranoid reading this, but it feels like the council has an issue with the individual or with the case. And so even if you get past that priority need hurdle, down this route, I feel like then you've got intentionality, local connection, and that's all going to be sort of where the council's going to lean to. So I don't know if I'm just oversimplifying it, because I, you know, can't take places to court, but I think maybe a fresh application would be what I would add to this, but I don't know how useful that is.
I mean, I'd speculate that it's not actually personal, it's just against the whole client group. That would
Sorry.
be so.
I've also seen the prison leaver. So
yeah,
as a prison leaver, like your risk of violence and things like that.
Yeah, I mean, I think this person's definitely vulnerable.
Yeah.
But I think potentially the problem you've got if you trigger a fresh application. So first of all, you're going to have the argument with them, and they'll say, well, we're not going to allow that because we're still on this one. But if you were able to do that, then effectively the council will immediately just issue a not in priority need decision, and not. I think that's what I think it seems to be that they're dead set on finding this person not in priority need, and I think I think this person will need a solicitor one way or the other, to basically have the argument with the council and win it. I don't think it'd be very difficult to actually win the argument. It's just about getting the council to actually act rationally and act fairly, which doesn't seem like they're doing that at the moment. I'd be interested to know if this is a London council or not, because it's pretty bad practice. So yeah, I didn't get a hard answer out of you guys in terms of whether Virgos has got capacity right now. Do you?
Yeah. I don't
There you go. So if the person's watching, the link is in the description of the video, or it will be. So there's like an initial form. Feel free to get back in contact with me as well if I can help out with anything in terms of just explaining anything about how to do it. So we're on question. I think we've got 2 more questions to go before we get into the live stream. So just to bear in mind, guys, we're not going to get that much time to deal with the actual live stream questions tonight. We'll do our best. But question 7, the answer is fairly straightforward. Is alcohol addiction in rehab considered priority need under mental health by housing? So couple of things on this. When we talk about priority, confusingly, both Part 6 and Part 7 of the Housing Act use this word priority. You've got medical priority under the Part 6 social housing register application process, and then you've got priority need under Part 7. Not quite sure how it would actually be under Part 6, but certainly under Part 7, there is an established kind of case principle that someone who is at risk of relapse into substance use it won't be they're not guaranteed to be, but they can be in priority need simply because of the risk of relapse on its own. And generally speaking, when you're working with people who are in recovery, they've probably got some other kind of issues kind of running alongside it quite often. So the answer is potentially yes for priority needs if they made a homeless application. But it's not guaranteed. You always have to make the argument. So that's if we're talking about the homeless application process. If we're just talking about the housing register process, then you'd simply need to read your local housing allocation scheme. So if you Google the council this is involved in and the term housing allocation scheme, you'll get the local policy, and then you'll have to look at to see what it mentions. I would be surprised if many housing allocation schemes mention substance use in general, because councils can basically set their own policy. They probably are not kind of particularly keen on taking people in who have got a history of substance use. So I'd probably be inclined to say it's probably not very likely, but you can only find out by checking. So it's entirely possible. It's a coherent thing to say, but I just don't know that the Part 6 route will really take it into account. Whereas the Part 7 absolutely does, because that's set by case law and that's kind of national. So anything to add on that one at all, guys? If not, I feel like Okay, now there are some. There's actually 11 questions. I think I'm not quite sure what's going on here. So very quickly, does a Section 21 homeless application, Section 21 involved in a homeless application change my bidding category with home choice? Potentially it would do, because Section 21, if you've been given a valid Section 21 notice and you're within 56 days of it expiring, then the prevention duty basically should be triggered. That will have an impact on the bidding category. Again, you have to look at the local policy to work out what that impact is. And then once the Section 21 expires, in most cases, the prevention duty will morph into the relief duty, which again might have a bearing on the banding. It just depends on the local policy. So the only way you can really answer this is if you just Google the council's name, housing allocation scheme, and then have a look in the detail of the banding section. There'll be a banding section which is generally kind of in the middle of the policy somewhere. The policy will be like 30 pages long often, but if you just look at the bands and it will kind of mention prevention duty, or it might even mention Section 21 actually, but it will mention prevention duty or mention relief duty, and you'll then get an idea of what band you should be. So it may have an impact. It's just about the local policy basically. As we've said before, local policies around the banding is always locally set, so it's always different. So question 9. Section 21 deemed invalid, 1 month left, license issue. I guess that's like a license issue with a landlord or something. I'm not quite sure. But sale agreed, so valid one is likely soon. In the meantime, housing registry application submitted. It's been a month and still processing. Thinking of asking MP to push for welfare panel to consider discretionary higher banding. Private rented, not an option. Hoping to secure council housing via registered before homelessness route once the valid Section 20 has been served to avoid risk of unsuitable shared accommodation, mainly due to child with severe anaphylaxis risk where any cross-contamination could be life-threatening. Do you have any advice, best way to avoid risk of shared accommodation, how to argue for priority banding even with an invalid Section 21? Would you recommend raising disability under the Equality Act? So there's a few questions kind of mixed in there. In terms of the anaphylaxis, that is a very, very good argument to say that you don't need, you should not be put in shared accommodation. But what I'd probably do is try and get a medic, GP or whoever, to make that point. So basically say, look, this is how bad it is. This is what the person's allergic to. And if they were to have a reaction, then there's a risk of death. That would be a pretty good argument to say that even if you were to go into temporary accommodation, the council really would be incredibly stupid to try and put you somewhere which is, kind of shared kitchen or toilet facilities. So that's a good argument. Therefore, I'm not quite so in one sense, I would say my default thinking on this would be to say, okay, well, run the homeless application as normal. Make by all means make the argument, go to the MP, push for a welfare panel to use its discretion based on the risk of death here. But in theory, you shouldn't have to, because in theory, the council should basically provide self-contained accommodation, which takes this risk into account. What you want to basically make sure is every time you speak to the council, every time you write to the council in an email, you include the fact that you're worried about the child's anaphylaxis risk, and you basically just point out yet again that there is a risk of death. That would be how I would tackle it, but there might be other ways of doing it here. So I don't know if you guys have got any additions to say about that one at all. No, cool. Okay. Question 10, fairly straightforward one again. Well, actually, it's not straightforward. It's an interesting one. So, hi, I live in Council A, and I'm applying to Council B as my son lives there. Do I contact my councillors here in Council A or the Council B councillors to help? So this is on the back of my kind of general advice that when you make a homeless application, it's good to engage with the local councillors. It's a really good question. I think the problem you've got is that if you go to your own councillors in Council A area, they have absolutely no sway whatsoever with the councillors in Council B area. But if you go to the Council B area's councillors before you move there, they're going to say, you don't live here, you're nothing to do with this yet. So what you actually might have to do in this situation is make the homeless application first, and then if something, and as soon as something goes wrong, then bring in the relevant councillor. So the relevant councillor would be whichever councillor's portfolio includes housing, and there's no kind of generic kind of title that they'll have. You'll have to look in the council's website to see what the councillor covers, but there will be one who covers housing. So that would be kind of, that would be the go-to. But I think you would have to wait for something to go wrong first, is my guess. There's no harm in copying the counsellor in and trying to have a conversation with them beforehand. They don't lose anything by doing that. It may, it's a reasonable thing to do, but they may say, well, look, until you live in the area that, you're not one of our constituents, so there's nothing we're going to do. That would be my answer. Again, interested to hear if anyone's got anything different to say about that one. But if not, we're on our last question from the week. So just again to say, guys, the best way to get your question answered is by submitting it during the week rather than on the live stream. Obviously, it's easier to clarify on the live stream, but you can just be present when we go through the questions. So number 11, should I write to my housing officer or council to give me a final decision letter since it has been over 56 days, or just wait? I've been provided interim accommodation by council and have been here for just over 2 months. My 56 days have passed. What do I expect to happen next, please? Does this mean I'll get main duty? So don't know about main duty. The fact that they haven't kicked you out of temporary accommodation yet or interim accommodation is a good sign, because if they think they can get rid of you, they generally will at the first available opportunity. So it's a good sign, but it's in no way kind of a guarantee that you're going to be owed the main duty. And I think at this point, if it's just gone over the 56-day limit, just kind of politely chase it. That would be my first approach. But then if you get no contact or whatever, then you start kind of increasing your contact with them and potentially start escalating it. So that would be my answer to that. You guys got any things to say about that one?
The only thing I would say is that if the person has been given temporary accommodation and the 56 days has passed, then it's likely that if they haven't been able to find them anything long term, they will have to accept a full duty because they're going to have to accept them as being in priority need. Am I missing something there? So I mean,
no, I think that's a rule of thumb, isn't it? I think, as I say, I think if the council thought they could give a non-priority decision, they would have done it already.
Yeah.
Because they're paying on a nightly basis right now. Cool. So first question from the live stream is as follows. Someone who suffers from autism and mental health has been in unsuitable interim accommodation for 6 months. His relief duty ended 3 months ago, and whenever he asks for an update or what is causing delays, he's told there is a high caseload and shortage of staff. From calling the council housing switchboard, an advisor has said from his notes that she can see that his housing officer has approved his application and passed it on for manager's approval. And this news came about 2 months ago. However, he's still not received an official decision letter and has submitted an extensive amount of supporting evidence. Is this reasonable for the manager to take 2 months to approve an application for housing officer has passed through? Could there be a reason why it's taking this long? So it's not reasonable to take that long. The reason probably is it's that kind of like weaponized incompetency. So councils deal with a lot of their problems just by being absolutely terrible and not responding to anything, because it does get rid of a lot of people. It is actually quite an effective way of working. So I don't think you should read anything negative into that per se. Personally, I'd probably be getting on the phone to the local relevant councillors, because councillors, one of the things they're probably best at is getting a council to actually, kind of chase them up and actually, issuing a decision when they should do. There would be grounds to complain here, although I'd probably save that until a bit later on, because even the delays in itself is something you can get compensation for. You get a few £100s for it. So that would be something worth bearing in mind. But obviously the priority right now is to know for sure that you're in priority need, that you're not intentionally homeless, that you've been kind of given the main housing duty. That's more important right now. But I think a complaint would be warranted as well. So yeah, anything to add to that one, guys?
Very quickly, if they're in unsuitable accommodation and they're still at the relief stage, and they haven't accepted 193, then one way to speed things up would be, and again, I'm saying this as a lawyer, if you had a lawyer handy, send a letter in accordance with the Judicial Review Pre-Action Protocol regarding the suitability of the temporary accommodation, and say that if they're not rehoused, then you issue judicial review proceedings. One way the council may think that they're cleverly sort of checkmating you on that one is by issuing a Section 193 duty and then say, you can't judicially review us now because we've accepted a full duty, and therefore you have to request a review of the suitability of your accommodation. So that would get you around that problem, except you would then have to request a review of the suitability of the temporary and hopefully get offered something suitable that way. But that would get you around the logjam of, because they'd probably go, somebody would say, oh God, this file's been asleep for however many months and they're threatening judicial review, and somebody will say, well, accept a duty and they can't JR us. So have a go. I hope that makes sense. But that's one tactical thing you could do.
Cool. cool. Next question. I think there's a multi-part. Just bear with me a sec. Oh, hang on. I've just. Oh, sorry, guys. I think have I missed one? Okay, no, it's just a very similar question, I think. Hold on. Am I getting confused here? So hold on a minute. I think these two questions are using very similar wording, which is what's probably confusing me. Hold on. So I think I've done this right. So person with mobility problems is waiting for the homelessness case to be resolved. Recently had a meeting with a solicitor and solicitor submitted a Section 204 appeal. Can you please explain, one, can a person instruct a solicitor to apply for interim accommodation pending the appeal, or is it solicitor's decision? And secondly, can submitting a formal appeal result in a case being resolved quicker? So yeah, Will or Karis, you up for answering this one? So I don't know the answer. Or you're on mute, Will?
Do you want to have a go, Karis, or should I jump in?
By all means.
Okay, so the answer to number one, can a person instruct a solicitor to apply for interim accommodation pending appeal, or is it solicitor's decision? Well, I mean, it's sort of both really, because you can instruct when the word instruct is used loosely in terms of solicitors, because you say I'm receiving instructions from my client. That doesn't mean they're sort of telling me to go sit over there, now get up, now sit down, that sort of instructions. And you have to follow it. So I would have thought, though, that looking at it logically, if the solicitor has submitted a Section 204 appeal, and I'm not sure, did it say what the actual negative decision was? It doesn't.
No.
But if they think there's a grounds for appealing, then you're halfway to getting grounds for getting temporary accommodation. Although the fact that you've got a strong appeal isn't necessarily the be all and end all. You've got to show that you'd suffer harm. And the way you do it is, it's really stupid, but at the 204 stage, you ask the council to accommodate pending the appeal. And when they say no, you then issue a second appeal. And that's an appeal against that's called a Section 204A appeal. And there you appeal against the refusal to accommodate pending the outcome of the 204. And you can apply for a sort of urgent hearing in that one. So you're not just waiting until the day of the main appeal. But the county courts are so dreadfully under-resourced, let's say, that it is a major struggle to get a hearing for a 204A appeal, to get an injunction. Whereas in the High Court, in a judicial review, you could get one within an hour. Whereas in the 204A appeal, to get an injunction requiring them to house you pending the outcome of the main appeal, it could take weeks. So I hope that, and sorry, can submitting appeal, and well, submitting a formal appeal, if they've done a negative 202, which is why you would appeal, or they failed to carry out a review, then submitting a formal appeal can only result in it being resolved quicker, in a sense that if you didn't appeal, they'll probably say, well, that's probably the last we've heard of you then, because we've said we're not going to help you and you haven't challenged it, so nice knowing you. So I'm not going to do anything else. So yeah, you definitely should appeal, because that's the only way of getting the case resolved.
Yeah. Okay. Yeah. Yeah. I think, as you say, there must be merit in the case anyway for them to be putting a appeal in. So yeah, it seems. I guess. I mean, you'd have that conversation with the solicitor, right? You kind of talk to them and say, look, why aren't you requesting accommodation? I need it right now, and you then kind of see what they had to say about it. But it seems to me to be part and parcel of the same thing, really.
Yeah.
So where are we up to? So there's a couple more questions about the complex needs team within the DWP. I don't think we can add anything that we didn't say last week to that, because the answer is we don't really know what the deal is. There's a question which I think kind of goes on the back of what we've been saying. So and if you can't get a solicitor, that's the $1 million question. The answer is that in certain cases, you really do need it to get a solicitor to actually win a case with the council. They can play it in such a way that complaining is not going to do the job. Complaining is often helpful and it can get things resolved without a solicitor, but it won't in every case. So when we're talking about, for example, the example was given about the priority need or the non-priority need decision and all this sort of mess up here with the split 202 process or whatever, then I think it's very difficult at that point to resolve it without a solicitor. As I say, all we can say about that is that, you know, Will's got the list of housing legally funded housing solicitors on his website, and when Virgos do have capacity, Karis and Will can take cases on through this route really. But other than that, unfortunately, that's just the sad state of affairs we're in really as a country. We don't have a judicial system which works and is just. So it's going to cost us down the line at some point, I'm sure. Question about a DHP form. So let's just get it all loaded up. Now, so DHPs are something which councils have discretion about their policy. So I can't definitely give you an answer. Well, I can't give you an answer for every council here, but DHP forms are specifically not something which are agreed forever. They're supposed to be temporary. They're supposed to push the council or push whoever to solving it in some other way. So give an example, in Bedford, you get a DHP for 3 months, and at the end of the 3 months, you've got to go back and apply for it again, which is the cause of a lot of distress and anxiety. So I've never, I mean, I just don't think that it's within the council's power to agree a DHP forever, although in effect they might agree to it indefinitely and kind of have this rolling kind of process of reapplying every 6 or 3 months or whatever, because it's actually doing the council a favour, because often it's because the tenant is in an unaffordable accommodation, and providing the DHP increases their income so that they can then no longer be homeless, if that makes sense. So I think that's, yeah, I mean, I don't think I can't add anything else to that, but I don't, I've never seen it being an indefinite, you know, kind of an infinite sort of agreement. Is something which is always kind of time based and kind of time limited. So I don't know if you guys are seeing anything different in terms of, no, not. I think that's just kind of pretty standard, really. Okay, so question 16. What's going on here? It's doing a weird stuff for formatting. Hold on. So what happens when a tenant is issued a Section 21 notice and paid their rent on the 13th of the month, and the Section 21 notice runs out on the 23rd? So basically, Section 21 notices, to be valid, have to get a number of things right, one of which is the rental period. So if someone's paying the rent on the 13th of every month, and the Section 21 ends on the 23rd of the month, then that says to me that that notice is invalid. I can't see how it would be valid. It would need to basically line up with the payment period. So if you're paying the rent on the 13th, a valid Section 21 would end on the 12th. That would be my understanding. But this is not my area of much experience. So again, anyone else want to kind of add anything to that or kind of explain that better than I have?
No, I can't really. I have to admit, I really hate these sort of cases because it just seems to have an excuse for lawyers to make huge amounts of money arguing over something, which I suppose it's significant, but it just always seems to me crazy whether you should argue about which date, the rental period stuff. But it's worth sticking in a defense, I guess, and seeing if a judge will buy it.
I mean, I think if you approach a local authority at this point and showed them the issue, the housing officers are motivated to basically sniff out anything that would make the notice invalid. So that would be what I'd probably do. Yeah, in absence of kind of definitely knowing what the answer is, you'd make a homes application via an email. This is a homes application and so on, and you'd attach a copy of the Section 21 notice, and you'd explain to them in the email, this is when I pay my rent, and let them kind of hash it out really. Let the housing officer pick up on it. Many housing officers would pick up on that very quickly and without much fuss really, because it's in their interest to do so. So that would be probably probably what my answer to that would be. Cool. So from this point, guys, we'll call it no more questions. So there's 2 more questions in the oh, hang on a minute, in the chat. An individual is at the point of reassessment of a non-priority decision on the grounds of vulnerability due to mental health. The individual is unsure if they want to disclose to the council that. Okay, so sorry, there's more to this question that will come in, so we'll come back to this question. And then, so if we just jump forward to the next question briefly, and we'll return to this one when it comes to it. Hold on. So what's the procedure when housing benefit is owed to vulnerable tenants with no income? Who do they speak to ensure the rent is rightly paid by housing benefit, please? So again, this is not my area of knowledge at all. I'm guessing we're talking here about a tenancy rather than temporary accommodation or something. So therefore, you need to speak to the council's housing benefit team, is my understanding, to basically sort that all out. So you can get housing benefit if you've got a zero income. You do need to, in my experience, you have to fill in a form which says I'm not getting any income. But the housing benefit, you don't need to be getting money from other benefits to get housing benefit. It's basically, if you've got no income, then that you'd absolutely be eligible for it. But I think you'd have to basically take the query to the local housing benefit team. And again, just do it all in writing, put the question to them, and just kind of see what they have to say about it. So just a bit more to add to that previous question. So a little bit more here, hold on. So yeah, question 17. An individual is at the point of reassessment of non-priority decision on the grounds of vulnerability due to mental health. The individual is unsure if they want to disclose to the council that they're abusing alcohol and cannabis due to PTSD, stress and anxiety, because they think that the council in general aren't so keen on housing offering assistance to alcohol drug dependence. What do you think? So yeah, I mean, you're onto something here. The law is actually really good around substance use. There's actually many places within the law where it treats it as a support issue rather than a kind of a crime or something. So for example, alcohol and drug use absolutely is part and parcel of the vulnerability assessment. What you'll often get with housing officers is that if they know that something is someone's using substances and they also have mental health issues, then they'll say, well, that's just drug induced depression or drug induced psychosis or something, as if that kind of means that it's not an issue. But the reality is that just because someone has done something which has led to their symptoms getting worse, that does not mean to say you're not in priority need. The council should be focusing on what are the symptoms of the issue and how are they going to be affected by being homeless. So, but you do have that whole kind of like lifestyle choice type mentality within councils. So I completely sympathize with this person's situation. I guess my default would be to just be honest with them, basically, and just say, look, this is what's happening. I mean, you can evidence. So I think if you look at the NICE guidelines for PTSD, it does very clearly say that it's associated with a strong risk of substance use. So you can maybe kind of go in from that angle and kind of say, well, look, this is something which the mental health diagnosis is part and parcel, is closely related to alcohol and drug use. So that might be something which maybe just kind of gets them to not think down the lines of lifestyle choice. I think if you start talking about self-medication and stuff like that to a council officer, most council officers, or many of them certainly, will just kind of like roll their eyes and think you're talking nonsense. So I think, I think you've got to be honest with them, but I think try and couch it and kind of just kind of make the point that it's something which is resulted from the PTSD and the anxiety as a way of coping with it, basically, and hope that kind of wins their sympathy. It shouldn't be a question of sympathy, by the way, and this is never a moral test. It's not, housing law is not saying, oh, you're a good person, or what does society think of you. It's saying, what would the law kind of apply to you, and how would it lead to there being assistance for you. So where you going, Shannon?
I wonder as well, and I'm not saying whether this is accurate to the person's situation or not, and again, there's no judgment, but whether framing it around actually the use of alcohol and cannabis being sort of down that self-harm route, because they've said abusing there, and it again just reframes it to potentially how the housing officers might think about it. That's just what I want to throw in.
Yeah, I think if it doesn't actually say in the question, but I think if the person's physically abusing or physically dependent on alcohol, that then leads to a number of other health conditions which are often related with it. So again, if this person's not already accessing substance use services, then I'd say give it a go. They're not magic. They're not going to magically fix everyone's substance use issues, but what they can do is basically carry out an assessment and be able to provide some useful information for the council to then consider. So that's something which you might bear in mind. So yeah, and then I think that's it, guys. So there's just a clarification on the final question as well. So housing benefit department only needs to speak to others in housing benefit department, don't they? Not the tenancy bullying housing officers. So it would depend on the situation. So it sounds like this is a messy situation, but basically, and it would also depend. If the tenancy officers are in theory at least trying to help a tenant pay the rent, then I would say it would be reasonable for housing benefit to be speaking with them, and consent and issues like that come into it, but I'm not quite sure. It would depend on what you've agreed to previously and stuff like that. So yeah, so I think that's much that. And then just final kind of wrap up with another bit on that last question, 17. How long after reassessment of a non-priority decision will it be possible to take to overturn a non-priority decision if the reassessment of non-priority decision is negative for the individual? So in a situation like we're talking about here, so let's say they made a non-priority decision today, and you then went to the drug and alcohol service tomorrow and got an assessment there, and that threw up new information which was relevant, then you can make a fresh homes application tomorrow, and the council would have to make this, go through the same inquiry process and make a decision again. So yeah, I think that's it, guys. Just to make the point, because I think this evening kind of made the point really well, that if you want your question to be at the start of the evening when we're a bit fresher, then put the question onto any video on the channel, and that means that we see it beforehand. So I'll send it around about 5 minutes beforehand, but it gives people a bit of notice. It means we've kind of read through the questions. It means you don't have a character limit. You don't have to kind of put questions over multiple things, and it's easier to anonymize it as well. So that is the best way to kind of probably get your questions answered here. But if you then come to the live stream live, you can clarify it and you can get additional information about it. So it's not that you don't have that kind of back and forth. It just means that you've set your question out, you've had time to think about it, and it's just easier to do, I'd say. So yeah, do consider that. Other than that, what we're doing Mondays. So Monday's not a bank holiday this Monday, is it? So yeah, Will, are we on for your channel on Monday? Or you're on mute? Or you're on mute, Will? It sounds very profound what you're saying, but
Yeah, sorry, I was saying I'll try. I promise I'll try because I feel like I don't want to say yes because then I've been failing to get my act together. But last weekend I was really busy, so I didn't get a chance to prepare. So this weekend, hopefully, I will.
yeah, cool. Okay, so we won't hold you to it. Well, it's all right.
But it'd
yeah,
be great if you guys can join me if we do.
Yeah, cool. Yeah. So yeah, and if not, if Will's there or not on Monday, then we'll be back here on next Thursday. So please, yeah, just hopefully this has been useful tonight. And again, hope you just kind of understand how complicated things can get within housing law. And the key thing is just to not give up. And for those who kind of, we said, might need a solicitor, then do have a look at the description of the video once it becomes, give it like an hour or so for it to upload properly. But that link will take you through to like a triage form for Virgos, and that might well be a route in if they've got capacity to take on the case.